Well, thanks everybody for coming tonight. This is our second Money Smart Week seminar this week. If you are interested in learning about how to avoid scammers, I have some information on that we did last night. But tonight we're going to hear from Joe Deeney. He's an attorney here in Solon, Iowa, and he's going to tell us all about the basics of estate planning. So here we go, Joe.
All right. Thanks, Alexis. It's my pleasure to be here. Alexis asked me to present tonight, and I view it as an opportunity to help educate the community and take that seriously. We have a small group joining us tonight. I know this is being recorded, so hopefully it's beneficial to anybody who views it in the future. I've muted everyone. I think everyone's muted at this point. If you do have a question, feel free to unmute yourself and ask a question during the presentation. I won't be paying close attention to the chat, but I'll check that at the end. If you have a question, you want to use the chat function, I will check that after I wrap things up. So today we're talking about basics of estate planning. And as brief agenda, we're going to talk about what's an estate plan, which documents are important for including an estate plan. We're going to talk a little detail on each of those documents so that you have an idea what's included, why things are included. And we're going to just touch on probate. And then we're going to talk a little bit at the end about what happens if you don't have a plan in place. Before we get started, I just want to tell you a little bit about myself, a little bit more. I've been practicing law since 2011. I am originally from Northeast Iowa, Waukon, and my family and I relocated to Solon in 2018 after I spent, we were in the Chicago area prior to that. So we're very happy to be back here in Solon and feel very fortunate to be here. So starting with the content, what is an estate? So an estate it's really your real property and then everything else personal property. And that can include the things in your home. It can include your bank accounts, financial accounts. The estate, when I think about it, is just everything that's owned by me in my possession as far as tangible personal property, and really anything that is titled in your name. So that is your estate. As far as estate plan, so I said here, we have an estate and we plan ahead. So the estate plan itself is designed to protect and provide for your spouse and your children. One of the ideal outcomes of estate planning is avoiding family conflict. That's a goal for a lot of people when they're choosing to put an estate plan in place. We can also provide for special needs individuals. We'll talk a little bit more about that later. That could apply to individuals that currently have special needs, or it could apply to someone who may have special needs in the future. And then we also, a lot of people will estate plan so that they can leave a lasting legacy. They want to leave a good memory for their family and don't want kind of the last portion of their life and the immediate period of time following their death to be cumbersome for their family or to create conflict. So you want to leave a lasting legacy and leave everyone with a good memory of you. I want to share a quick story. My wife, Emily, and I have a friend in Illinois who we've known for a long time. And she unfortunately had her father pass away in the last couple of years. And her father had failed to put a will in place and failed to have any estate planning documents. And this is a story that some of you may have heard before, but unfortunately it's been almost 2 years and she's still working through the probate of her father's estate because of the lack of planning and because there's conflict among family members about who's going to get what. And that's one thing we absolutely try and avoid when we do estate planning and we put a will and other documents in place. So I want to talk about what documents we should have at a minimum. I've had couples come to me with wills and other estate planning documents that were created years and years ago. And I want to help them, ensure them that things are updated. So first we will talk about the will, the last will and testament. Preferably it has some contingent language in there for special needs. I mentioned that before, and we'll touch on it again. The financial power of attorney is another very important document. It's one that I've seen recently actually be missing from an estate plan of some individuals that have done planning in the past. So it's something that's critical to part of your estate plan, and we'll talk about why. And then your living will. Sometimes it's referred to advance directive, sometimes it's referred to declaration relating to life-sustaining procedures. That living will usually is incorporated into your medical power of attorney. And then as you can see on the slide, there's also a portion of that medical power of attorney, the Hipaa authorization. And we'll talk about that to explain that a little bit more. The last, number 4, is declaration of designee for final disposition. This one I don't place as highly as those other 3, as far as, being a mandatory part of your estate plan, but it is something that can help alleviate some confusion when you pass away. Okay, so the last will and testament, we're going to talk about that a little bit. We've all probably heard of a will. Most of us probably have an understanding of what a will does. It's a written document signed in the manner that's laid out by Iowa statute, which allows us to dispose of property upon death and allows us to dispose of property according to our wishes. In Iowa, there are 2 witnesses required to watch the testator, or the person signing the will, sign, and then there is a self-proving affidavit that's done. And that self-proving affidavit is what allows the will to be admitted to the court without further evidence. If there's a lack of self-proving affidavit, you still may have a valid will, but there's some additional hoops you may need to jump through in order to have your will admitted to the court. So I've seen some of those recently too, where maybe it's a will that was done quite a long time ago, and there was no self-proving affidavit included. So, maybe depending on what's included in that will, it might be time in those situations to update things and kind of bring them up to current timeline of what's required when you admit a will to probate. So continuing with the last will and testament, obviously a will, it allows you to nominate who's going to be responsible for helping administer your estate. So I'm sure some of you have heard the word executor, and that is the person who you're appointing to really take care of things after you pass away. It also allows you to nominate guardians for your minor children. This is a big one. This is a big one for me. My wife and I were going on a long trip, which included some airplane flights. And this was prior to becoming an estate planning attorney, but both of us really had to stop, and we really paused when we considered what the outcome of that trip could be. If we were together, something unfortunate were to happen, we really started to think about what might happen to our children. We realized we hadn't had an opportunity to put a will in place. We hadn't appointed a guardian. So again, this is a big issue, and the reason why a lot of couples with minor children decide to put a will in place. It shouldn't be the only reason, but it's a big one. Making sure that you're appointing someone to take care of your child, and you want to be able to pick that person or to make a decision about who you think should be the guardian for your children rather than allowing the court to ultimately decide. So Emily and I got our will done, and that definitely put us at ease before we went on our trip to make sure we had something in place that would, appoint a guardian in case we were to pass away. So a will also can determine when and how your children will receive property that you leave to them. There are different, in a will, you can include a testamentary trust, for example. This would be a good example of something you would do with minor children. You can actually incorporate language that would establish a trust, a testamentary trust. And what that would allow is money to be placed in the trust until your children reach a certain age, and kind of keeps it safe while, when your child is below the age of 18 and even between the ages of 18 and 25, when they may not do a good job of taking care of that money. So there are things that you can do in a will that allow you to kind of control your assets even after you pass away. A little more information about wills. Wills have to be probated. So I mentioned probate when we started. And when you pass away, your will is admitted to the court, and that's kind of where the probate process begins. And the court has oversight of the administration of your estate at that point, and it is a public process. So most people are aware that once that will is admitted to the court, it's going to become public. The administration of your estate is a kind of a public proceeding. So what a will does not do is it does not provide and help you while you're incapacitated. So the documents we'll talk about here shortly, the financial power of attorney, the medical power of attorney, are documents that cover you during that period of incapacitation if you happen to have that in your lifetime. But a will doesn't cover that area. A will only becomes really effective upon your death. All right, well, I'm going to touch on, before we get into the power of attorneys, I'm going to touch on trust just briefly. Obviously, this presentation is about the basics of estate planning, but more and more often, people are using trusts these days to ultimately avoid probate. So what a trust is, it's a private agreement between a settlor and a trustee to manage trust assets in certain ways for the benefit of your beneficiaries. So you are, if you're the person creating the trust, you're the settlor or trustor, different terms that are used. And you're also, when it comes to a revocable trust, you're almost always the trustee, the initial trustee of that trust. So you're not only the person creating the trust, you're the trustee of that trust, meaning you're the individual that makes decisions and has control to take certain actions with regard to trust property. As I mentioned, a revocable trust, a trust may also be irrevocable. And irrevocable trusts are less common than revocable trusts because they're more complex to set up. As it indicates, it's not revocable. When you set up an irrevocable trust, they're designed to stay in place, and there's certain benefits to doing that. There's potentially some creditor protection when you set up an irrevocable trust. I'm always happy to discuss these things after the presentation if anybody has any questions. I'm not going to get into too much detail. I will touch on some of the benefits here in a moment. But as it indicates there, you can have more than one beneficiary associated with the trust, just as you could with a will. So with regard to revocable living trusts, the big benefit there and the difference between a trust and a will is that a trust avoids the probate process. So when you set up a revocable trust and you transfer property and assets into that trust or in the name of the trust, it's the trustee that controls that. And when you pass away, your trustee is able to administer the trust and control those assets and distribute them to the appropriate beneficiaries outside of the court. So the trust itself is not admitted to the court. And because it's not admitted to the court, it's a private proceeding for the most part, unless for some reason there's a conflict and the court needs to get involved. Most revocable trusts are going to be administered completely outside of the public view. The benefits of avoiding probate are more likely an ease of administration. You're able to also save some time because you're not waiting on the court to make a determination of when or where an asset is distributed. It's usually less hassle for your children or your beneficiaries to administer a trust because it is private and it is done outside the court. And the big one for most people, the reason most people will set up a revocable living trust is to save money. So by that, I mean, you're avoiding court costs and attorney's fees. You're avoiding the fees and costs associated with probate, which can be significant. Usually, if I'm talking to someone about a trust, if they're considering a trust, I usually tell them to estimate about 2% of their gross assets toward probate fees. So that means adding up the value of your home or the equity in your home, bank accounts, financial accounts, really anything of value other than life insurance proceeds. You add all those things up and take 2% of that. That's about what you can expect will be paid in probate fees when you pass away. I'm not going to get into detail on irrevocable trust other than, again, reiterating it's more complex, but the benefit of having that complexity and losing some control of those assets. I don't want to mislead anyone and imply that you're losing an asset, because that's not the case, but it's designed that way to allow for creditor protection. And this presentation is too short. I could probably talk for an hour or two on irrevocable trusts alone. So if there's a desire to have that done in the future, I'm happy to, but I'm going to leave it at that for now. So special needs trusts. This would be it's different than a revocable trust or an irrevocable trust. I usually refer to these special needs trusts as supplemental needs trusts, and they're designed to protect disabled beneficiaries' eligibility for government benefits. They can help provide for a higher quality of life for someone who's disabled, provide a framework for care and management of assets, allows when you're able to incorporate supplemental needs trust language into a will, you're allowing the parents to kind of express their desires about what should happen if they have a child that is on government benefits. And as a couple bullet points there indicate, you're protecting assets from creditors, predators, and then definitely extending the life of assets. So contingent special need trust planning incorporated into a will can be very beneficial. I tell people it definitely adds some pages to a will to incorporate this language, but it doesn't harm anything to include it, even if there was no need for a special need trust in the future. It's just really a backup in case. An example I use is you have a child who may get into a car accident and become disabled and have to apply for government benefits. And this type of language will help ensure that those government benefits are not lost, or that the eligibility for those government benefits are not lost because of a big distribution they may get upon your death. And again, this is another area that can be talked about in detail for an hour alone. So I just wanted to highlight those few key points. All right, moving on to the financial power of attorney. This is, most people heard of a will, but I think less likely, at least in my experience, or less often, my clients here of the importance of a financial power of attorney. You know, if you're going to a doctor on a regular basis, you might have even had someone assist you with filling out a medical power of attorney, but a hospital is not going to assist with a financial power of attorney. But what this document does, is it allows you to appoint an agent to act on your behalf in financial transactions if you were incapacitated. So this document can either be springing, meaning there's proof that a certain condition has been met. Usually that condition is that you're incapacitated, or it can be immediate. And most of the power of attorneys that I have clients sign are immediate, meaning they're effective when they're signed. It allows your agent to act on your behalf whenever needed. So there's no need to prove an incapacity in order to use that financial power of attorney. Durable means that the power of attorney stays in effect after the principal becomes mentally incapacitated. So that's a part of the financial power of attorney itself, is durable. And as far as criteria for signing this document, the state of Iowa requires it to be notarized or signed by, or excuse me, witnessed by 2 individuals. The financial power of attorney, as I mentioned, applies during your incapacity. It can be springing or immediate. So if you sign a power of attorney today and there's no language indicating that it's springing, it will go into effect and it will be effective until your death, unless you revoke it. So at any point, as the person who creates a financial power of attorney, you have the ability to revoke that document. You have the ability to create a new document, appointing a new agent. So, and they're fairly straightforward documents to complete, and they're very important. I can't stress the importance enough to having a document like this in place as a part of your estate plan. So going from financial power of attorney, we move on to living will and medical power of attorney. Some people are confused by the living will language. I've had individuals ask me if a living will is the same as a will. It's not, which is why some people refer to the living will as an advance directive, as I mentioned before, or declaration relating to life-sustaining procedures. Usually I'll refer to it as a living will just to keep things simple and straightforward. And if there's any confusion, I can explain that. But a living will allows you to put in place language, basically indicates that if you have an irreversible and permanent state of unconsciousnness, if you're in a vegetative state, that you will not be, your body will not be kept alive with life-saving equipment or equipment that would keep you alive. So it's really a paragraph long. The language is fairly consistent from one living will to the next. So the living will gets incorporated most of the time into the same medical power of attorney document. And the healthcare medical power of attorney document allows you to appoint an agent to act on your behalf to make medical or healthcare decisions. So whereas the financial power of attorney, you appoint an agent to make financial decisions, this one obviously is to make healthcare decisions. There's language in that medical power of attorney that allows you to address organ donation. The requirements for the medical power of attorney are similar to financial power of attorney in terms of making it effective. There's notarization or 2 witnesses, and that can make it easy. You know, if you're going to an estate planning attorney, most of the time they're either going to be a notary themselves or have someone in their office that's a notary. So a lot of the time those documents can be done very quickly after someone requests them. And the power of an agent to act exists only when a physician makes the determination that you're unable to make your own healthcare decisions. That can be a concern for some people, who don't fully understand what this document does. It doesn't grant someone the ability to make healthcare decisions in your place while you're still capable of making those decisions. It's only really effective when a physician makes the determination that you're incapacitated and you need someone else to make these decisions on your behalf because you're unable to. So the Hipaa authorization it's a part of the medical power of attorney. It's a separate section in that document, but it's an important document. You are likely asked to sign a new Hipaa authorization, on an annual basis when you go to your physician's office or you go to the hospital. They ask you to sign that authorization. You have the ability at that point to determine who you would allow them to give access to your medical records. So if you think about the medical power of attorney, you're appointing someone, an agent, to make a very important decision, a healthcare decision on your behalf. So you would want that person to have access to medical records so they can make an informed decision. So that's what the Hipaa authorization does. It allows your healthcare provider to release that protected or private health information without avoiding these federal HIPAA privacy rules. So the living will, medical power of attorney, and Hipaa authorization all become part of one document. In most cases, not always the case, but in most cases for someone who wants living will language, and that's incorporated into the medical power of attorney. And that document, again, doesn't take long to create. It's extremely important. The consequences of not setting up a financial power of attorney or medical power of attorney can be the need to establish guardianship or conservatorship. And those require a lot more time. There's obviously, if you're in a position where you need to be appointed a guardian or conservator, the court's going to be involved, and there's going to be higher costs involved than had you just established a financial power of attorney or medical power of attorney. I'm not going to say that if you have financial power of attorney or medical power of attorney that you can always avoid having guardianship or conservatorship established. It's not going to apply in all situations, but in a lot of cases, having those documents in place can help you avoid having to set up a guardianship or conservatorship. So, kind of to summarize what we should each have at a minimum: the last will and testament, and as I indicated before, with some contingent special needs trust language, financial power of attorney, and your living will and medical power of attorney with that Hipaa authorization language. I didn't include the declaration of designee for final disposition, but I'll touch on that. The reason I don't include it in this slide is a minimum is because that document allows you to appoint an individual to handle funeral arrangements, ceremonies after you pass away. The one thing you can't do with that document is indicate what you would like done as far as funeral arrangements and ceremonies, but it allows you to appoint one individual and a successor individual, if you would like to make those decisions on your behalf. So that is less critical in a case where you maybe you have a couple, a husband and wife, they have 2 children. In a case like that, where there's a trusting family, there's an awareness even in the community or by the funeral home who the family members are. It may not be as critical in that case. When it does become critical is if you have an individual who has a child, maybe their spouse passed away previously, and they absolutely do not want their child handling their funeral arrangements or ceremonies following their death. Without this document, that child is going to be the person responsible for making those decisions. So in that case, I would say it is an important document, because you could maybe pick a trusted friend to handle those funeral arrangements or handle the ceremonies that take place after you pass away. I've had cases where individuals have made similar requests. They've indicated that their child was not going to follow their wishes following their death. So this document became very critical to them and put them at ease, knowing that when they pass away, things are going to go according to their wishes. So I just talked about kind of the basics, the minimums of what should be an estate plan. A more comprehensive estate plan may include a revocable living trust, something more substantial than a will. But even if you decide to do trust planning and incorporate a trust into your estate plan, you're still going to have a last will and testament. You're still going to have a financial power of attorney. You're still going to have a medical power of attorney. You may or may not include that declaration of designee for final disposition. And again, there's different options for what type of trust you may incorporate. And while minimal planning, obviously a will is certainly, having a will in place, is certainly better than not having a will in place. It may not be the ideal approach for everyone, that minimal planning. And it really just comes down to your feelings about what you would like to have happen after you pass away. It comes down to your specific circumstances. And that determination really has to be made on a case-by-case basis. Because what fits for one person is not going to fit for another. What I will say is I've had people come to me and say, I don't need a will. I barely have anything. I don't have a lot of money. But I've also seen in similar situations where there's not a lot of money, I've seen family conflict arise because you can be, I'm sure some of you could probably relate, maybe you've experienced it, but there can be fighting over a fairly small amount of money when it really things get real after someone passes away. So I always recommend a will be put in place, even if there's a feeling that it doesn't matter. It's going to be distributed according to Iowa statute. It's really important in almost every case that a will and those other documents are in place. So I've already started to talk about the consequences of not planning, that family conflict. My goal when I do this, and really that's the reason I do what I do, is to help maintain family harmony and avoid that family conflict that could arise when a family is fighting over when a parent passes away, and there's conflict that can arise. It's never a fun situation. I have a brother-in-law whose father unexpectedly passed away, and he hadn't done the planning that he should have. His mother had passed away and his father had remarried. And when he passed away, there was some pretty significant conflict between the children and their father's new wife. And it was very unfortunate to see, with some planning, with some direction in a will or a trust, it would have helped avoid a lot of that conflict. There's no guarantee that everyone would have been happy with whatever decisions their father made, but at least it would have avoided conflict between the beneficiaries involved. So that's always, it's really my top priority when I'm planning for someone, is helping maintain that family harmony to ensure that siblings can still get along, to ensure that in that time of grief, a family doesn't have to be fighting with one another, considering anything other than helping each other through that process, through that time. Other consequences of not planning are assets going to someone other than the individuals you would want them to go to. So as we've discussed, in your will, you decide where your assets go. Who do they get distributed to? And without that will in place to give that direction, everything is going to flow and be distributed according to Iowa statute. In some cases, the result may be exactly as it would have been had you put a will in place, but there's certainly cases where that's not going to happen. So really, it's all about making sure the assets go to the proper place. Incapacity, this obviously applies to those power of attorney documents. I already talked about the need potentially for guardianship conservatorship when you don't have those power of attorney documents in place. So, you're really investing a little bit in order to potentially save a lot of time and hardship and money in the future by putting those simple power of attorney documents in place. And I talked a little bit already as well about the not having some contingent special needs or supplemental needs language in a will. You're incorporating language that will ensure if a parent passes away and they have a disabled child, that disabled child who might be on government benefits is able to maintain those government benefits and not in a position where they're getting a large chunk of money that might eliminate their eligibility at that point. So another thing I want to talk a little bit about is the number of people out there that don't have an estate plan in place or that don't have a will. By most estimates, 50 to 60% of people don't have a will in place. And, that might be shocking to some, but to others, it may seem accurate. I think when I first learned that statistic, I was a bit surprised. And, you can just imagine the amount of conflict that's created out there when 50% of people are passing away and don't have a will in place. So it's very important. You should never feel embarrassed about talking to someone, an estate planner, about not having a will in place. Really, there's no time better than now. You could be 21, you could be 81. It doesn't matter. If you haven't put your estate plan in place, start now, because it can save a lot of headache, it can save a lot of time, it can save a lot, help maintain harmony and in your family. And that's obviously very critical. So you shouldn't feel embarrassed if you don't have something in place, and start the conversation if you haven't yet. So I'm going to open it up for questions. Obviously, we have a small group today. I'm going to allow for some questions if anybody has any. And what I do want to say is if you're viewing this in its recorded format, feel free to call me if you have questions after this. An hour is not a great amount of time to get through, and I know I'm short of an hour at this point, but there's certainly a lot more that goes into planning for a family, and there's specific circumstances with each family that can change what I might recommend personally as an estate planner that a family put in place. And you can't really make that determination just from a presentation like this. There's an analysis that's involved to make sure that a plan is appropriate. So whether it's me or another estate planner, I encourage you to make a phone call and set up a time to meet with someone if you don't have a plan in place at this point. So does anybody have any questions?
I have one, Joe.
Yeah,
When somebody is thinking of coming to an estate planner, what kind of documentation should they be prepared to bring with them
yeah,
as they make an appointment to come talk?
that's a great question. Um, I I have a document that I have. It's a worksheet that I have, um, whether it's an individual or a couple fill out, um, and different estate planners are probably going to have some different criteria on what they request be brought in. Really, at that initial appointment, I don't request that a lot be brought in. You know, that initial appointment. Typically, I'm doing a free 30-minute consultation where I'm just kind of getting to know the person. I'm um, starting to understand what their family situation is, starting to understand a little bit about their financial situation. If someone is interested at that point in moving forward, I'll provide the worksheet. And the information that's in that worksheet is typically, obviously, personal information about them, you know, date of birth, their address, phone numbers, that type of stuff. Similar information for their children, so I can understand their family. And I'll also ask a series of questions that helps me gauge what's important to them. What are their goals? And I'll ask some questions about their financial assets. So that can help us make a determination of what type of planning would be appropriate. You know, should a will be put in place? Is a will sufficient, or do they have some significant concerns about the probate process and we're trying to avoid that? Or if they have enough accumulated wealth that putting a trust in place up front would help save a significant amount of money by avoiding probate. So there's a personal information, financial information, and then really just some questions that help me identify what the goals of that individual or couple are. Any
I
other
have a couple
questions?
questions, if I
Sure.
can.
Yes, please, Susan.
The Hipaa authorization, is that an entirely separate sheet, or is that a statement that's on the POA form? Because I don't remember seeing that, but.
Okay. Yeah, it's usually, so there's a format that's used by most attorneys in Iowa. It's usually the last couple pages of a medical power of attorney document.
Okay.
And it'll become fairly clear to you. It references, you know, release of protected health information. And there's a separate area for a separate signature than what you would sign with the medical power of attorney.
Okay.
And so depending on when you had your medical power of attorney completed, it's possible that it wasn't included at that time. So it might be worthwhile taking a look at. But if it's been done in the last 5 years or so,
Yeah.
that HIPAA authorization language should be incorporated into the last couple pages of that medical power of attorney.
Okay. A question: if you want to make specific assets, you want them to go to a specific child. You know, normally
Yep.
the will says we want to divide all our assets amongst our 3 children, but if there are
Yes.
specifics, how is that handled?
Yeah, I mean, there's just there's absolutely a way to designate a specific asset to a specific person. There's just language incorporated into the will that makes that direction. I've had that request on many occasions. There might be a piece of property that's being farmed by a child, or that a parent wants to make sure goes to a child. So I just incorporate a reference to that parcel of land and direct it to go to a specific individual. So there's a direction, there's language that can certainly be incorporated to accomplish that goal.
Okay. And the last question I have is, we have a daughter designated as our executor, and our financial POA, and she has divorced and remarried, has a different last name now. So do we need to go back and have all of that, need to make sure that all of that's changed now and updated, or how significant, how important is that to do?
For the financial power of attorney, you know, I would be more concerned about the medical power of attorney, because with a financial power of attorney, you know, your daughter would probably be able to show proof that they are the person that's indicated in that document. You know, there would be some time to provide that verification. Whereas with a medical power of attorney, I wouldn't want a physician hesitating that this isn't the person that's indicated in this document. So again, there might be time to do that. There might be the ability to do that. But if I'm kind of putting myself in the shoes of a physician, and I might hesitate if the individual indicated in that document has a different name than what's being shown on a driver's license, or
sure.
Again, that would probably be the worst case scenario. You know, a physician might be able to use what I usually always incorporate, you know, an address on those documents, a phone number. So those are pieces that might be used to make that verification as well. But it certainly doesn't hurt to get them updated and provide the current last name, just as a peace of mind to ensure that there's no complications.
Okay, thank you.
But yeah, absolutely. Any other questions? Okay, well, as I said, if you're looking at this recording and you have questions, feel free to reach out to me. Feel free to reach out to any other estate planning attorney in this area. You know, my goal, as I mentioned, is to make sure I'm helping maintain family harmony for the families in my community. And I know that's the goal of a lot of estate planning attorneys. The attorneys that do this work, from my experience that I have the opportunity to talk to on a pretty regular basis, are all, you know, they're all people that have a common goal. You know, they're individuals that I haven't run across someone who has a poor attitude in estate planner. So I think a lot of us go into this line of work because we have the desire to help, and you know, we have the desire to see our communities kind of prosper and make sure we're doing everything we can to help families maintain that harmony and allow for a smooth transition after someone passes away. So Alexis, again, thank you for inviting me to present today. I appreciate it. And
thank you so much for coming. We appreciate you.
Absolutely.
And I'm gonna stop that recording.